Yes, I welcome you all to the Legal Charity. I kindly request to subscribe and turn on the notification button so that you get updated whenever we post any video. So today's video, I'm going to dedicate it to Council Lilian at IUIU Kaboja Females Campus. Council Lisa, IUIU Kampala Campus, thanks for always following. So today's video, we're going to look at equity. So if it's your first time to hear about equity, then this is the right time to get to know what equity means. Equity simply means fairness and justice. That's what it means. Remember, we have both common law and equity. Now we want to know we want to differentiate between the two. What is the difference between common law and equity? And when did the equity come into Uganda? And when is it applied? And what are some of the equitable remedies? When you know that, you are good to go. And it's some brief background of how equity came into existence into Uganda. As I have told you, equity means fairness and justice. Remember, common law was harsh. It had strict rules. So equity comes in to come and bring in some equitable remedies that can be applied, that are not that strict like common law. That's equity. And what are some of the examples of these equitable remedies? Some of these equitable remedies, we shall have an injunction. But before we go any further, what you have to know is that common law, when it comes to common law focuses mainly on monetary compensation, not stopping a wrongful act. So an example of equitable remedies, there are some court orders that are given and they are equitable, not from common law. Remember, common law is strict. So examples of equitable remedies, we shall look at an injunction. An injunction is simply a court order to stop a wrongdoing. As I have told you, when it comes to common law, they will not stop you from doing it, but they will wait for you to do, then they tell you to pay damages. Then when it comes to equity, they will stop you on the way when you are still doing it. An example, if A owns land, and then B will come and build on A's land that does not belong to him, then what will happen when it comes to common law? They will leave B to construct the house completely without any interrogation, and then right after the building is complete, they will tell B to pay damages, which is not the case with equity. For equity, they will court will order an injunction to stop B from proceeding with building on A's land. That's an example of an equitable remedy. Specific performance is another example of equitable remedies. Specific performance, this is where a court will order a party to fulfill their obligation. Unlike common law, I'm trying to compare to show you how common law initially was harsh and how equity came in with solutions. So specific performance is also an example of an equitable remedy. So once a court orders specific performance, then it has provided an equitable remedy. What is specific performance? Specific performance is a court order to make the party to do their part of a contract. Specific performance is a court order to encourage the party to carry out their obligated duty during a contract, their contractual duty. For example, maybe A enters into a contract with B, maybe to buy land. A wants to buy land from B. Then what will A do? They will make a contract, but then A will fail to transfer the title to B. When it comes to equity, of course, when it comes to common law, it will be harsh that whoever has a title is the owner. So if they didn't transfer, then it does not belong to you. Instead, the court will order, when it comes to common law, that you pay damages. Then you pay the damages. But when it comes to equity, they will require you to perform that specific obligation that you agreed upon in a contract. So if A you intended to sell a land to be, and then you failed to transfer, the court will make you to transfer that land. That specific obligation that you two had agreed initially. Are you seeing how equity came in to solve a number of issues? Then also trust is another example of an equitable remedy. Trust. What about trust? Trust, this is where maybe a father leaves property, maybe with a friend, maybe the children are still young, that please, you keep this property. When my kids grow up, you will give them. Then a friend, they are along the way, they fraudulently maybe changes the title of the property and then takes the property from the children. When it comes to that, equity will come in and intervene and will make sure that the children get their share and get everything that was required. Okay, so that they get anything that was being promised to them by their late father. Those are some of the examples of equity. Now at least you have a wider picture of what equitable remedies are, and a difference, a slight difference with common, as I told you, common law, monetary damages. That's what they know. Equitable remedies, as you have given you some of the examples. But how did equity come about? Remember, some of these laws we do, most of the laws that we use, they came from British, England, those countries. We just adopted, and as they moved on, we started making our own. So the origin of equity originated from England. That's its country of origin. It originated from England, and during the medieval period, that's when it originated. And it originated as a result of the rigid and harsh common law. So these people saw how harsh common law was, and they had to bring in equity. That was in England. Of course, I will tell you how it came in Uganda, how we adopted it. But initially, there was common law, and the common law in the medieval period was practiced in 3 courts. There were 3 courts that practiced common law in England. That there was the King's Bench, and of course, these courts, they all operated different cases. So when you have this issue, you know which court to go to. When you have this, you know which court to go to. So we had the King's Bench. This one handled the cases that involved the crown. So if you had any issues related to crown, you know which court to go to. These were common law courts initially, and you want to see how harsh were they that now prompted the coming into of the equity that we are looking at. So these 3 courts are the King's Bench. When you had issues relating to cases relating to crown, you could go there. Then the courts of common plea, these ones handled disputes amongst the common people. So if maybe you have issues between yourselves, you know which court to go to. You can't go to the King's Bench because that was majorly for crown. Okay? We want to see how unfair were they, because we are seeing that even people are being favored. They have a court where their issues will be handled. Then the 3rd court was the Exchequer. Exchequer was the 3rd court. This court majorly handled dealt with revenue that was collected. So any matter that related to revenue was handled by the Exchequer. That was the Exchequer court, that pronunciation, but that was it. So those are the 3 courts. If you had the matters between the common people, you had to go to the courts of common plea. Crown, King's Bench. Revenue, you know where to go to, that Exchequer. So but the writs, of course, the writ system. Remember, back then we had the writs before the coming into of courts. So the writ system required the plaintiff, all aggrieved parties, to fit in their grievances within these courts. The writ system required that if you have any matter relating to any issue, if you cannot fit them within these 3 courts we have, then we have no remedy for you. Can you imagine? Remember, as time moves on, the number of issues that come on board that were not initially there, as you saw that the law keeps on transforming. So here they are telling you that if you have any issue, any legal issue that you want to be solved, you must fit in within these 3 courts. Okay, and time wasn't and like things wasn't with the coming into force of the Oxford 1958, which abolished all of the writ system. The writ system was brought to an end by the Oxford 1958. That means even the writ system that was kind of there, it was also removed. Now you see, people are going to have very many grievances. People are going to have very many issues. The writs that were at least there for them, they have been abolished, completed, and also initially they were there, but still partially helping. They only tell you that you fit in. Your writs must fit in within the existing courts. Okay, so we see that now we are seeing how equity is coming in. Grievances are becoming many. Now the writ system have been abolished completely. So how did equity come into place? We see that very many grievances came into place at that time after having abolished the writ system, and people had very many grievances. They were frustrated and they had to go to the king. Of course, this was their leader to present in their their issues. What did the king do? What did the king did? The king had a chancellor, just delegated that, please members, Mia Mori is busy, you go to my chancellor. So the chancellor had to come in and handle these frustrated people. The issues that were all these people, the issues that they had that were not solved. So when they came to king delegated to chancellor, said, you people, you go to the chancellor. Okay, so the chancellor started handling these people, and remember, chancellor was the keeper of the king's conscience. So handled that on behalf of the king, was the king's representative. Okay, so as a result, this led to the court of chancellor. This led to the court of chancellor, and the court of chancellor was the first court to carry out to practice equity. Chancellor, having appointed by the king, established the courts of chancellor. This is the first court that practiced equity. Are you seeing how equity is coming into place? Yes. Then how is equity applied in Uganda? Having seen how it emerged way back in England, how did it reach to Uganda? That is the question to ask. Of course, you know our laws, as I told you, they are not. We adopted many of these laws from the colonialists, those who colonized us, and very many. As time comes on, we just amend. In Uganda, we adopted equity from the Judicature Act. So the Judicature Act stated that their courts must apply equity, statutes, and common law. So we adopted equity from the Judicature Act, which stated that this theory should be applied. Of course, now you can see where the issue will come from. The Judicature Act will say that these three things are going to be in existence. And of course, the Judicature Act came in and solved a number of issues. Remember before, people, when this courts of chancellor was established, we saw that people one would go to the courts, one would go to equitable courts. If you got, for example, if one has a matter, would present it to the common law court and also to the court of equity. Then here we'll get a compensatory remedy, then the other side may an equitable remedy. Are you seeing how the two are contradicting? And this was clearly explained in the case of Earl of Oxford, that where common law and equity are at like where common law and equity are at cross purposes, equity shall prevail. So if they are at cross purposes, equity shall prevail. Of course, you expected where this one will go and present this to the equitable court and also to the common law court. Here they give you another decision, here they give you another decision. So here, the case tells us that equity shall prevail. So they saw that there are very many issues were rising up as a result of this, and they had to bring in the Judicature Act that tried to solve all this. Thank you all for watching. I kindly request you to subscribe.